So, Rusty, in your practice, where do you see the most intersection between family law and criminal law with your cases?
And I'll tell you, Gerard, I would say a very high percentage of the cases that I deal with on a daily basis have some bleed over, or certainly the potential for bleed over. I mean, we can start, kind of with the misdemeanors and work more towards the felonies. But a lot of times, one of the difficult things, well, if you have, and this would be a question to you, if you have a divorce proceeding, a family law proceeding where everything is equal, well, not everyone's a good player. So how can they create an advantage, right? It's one thing to say things about someone. It's another thing to say things about someone and get them arrested, right? And so often what we find, and it's very frustrating in my practice, what we're really after is a full, thorough, and unbiased investigation by law enforcement. And many times in the family law arena, when it bleeds over into criminal law enforcement, they're unable to do it, or maybe they don't follow up quite as we wish they should or would. And of course, the reason why is a lot of times you have someone who's trying to create that advantage, and they're going to make it in a way that it's unanswered for. So when you have something like a domestic violence battery, battery, by the way, is defined in Florida as any unwanted touching. That's a battery. Now, there's some common sense that goes to that, but at the end of the day, it doesn't have to leave a mark. It doesn't have to be closed fist. It can be a push. It can be bumping a shoulder. It can be any number of things. And they're very serious about these battery cases, especially when it gets into a domestic relationship. And I'm talking about law enforcement, and they should. There are all kinds of studies where higher level offenses many times start with a behavior that's violent and domestic violence. But
It's
I
kind of a
say that
it's a gateway crime in some ways.
it is, but I say that to say, you know what, they can't leave it unanswered for. So when there's an allegation, they're going to make a report, whether the person that's being accused is there or not. And they may not be able to get up with the person accused, or it may be a second officer that actually makes the arrest, in which case there is no other side of the story. So effectively, just based on one person's accusation, suddenly we have a criminal charge. And Gerard, you've done some criminal law. It's a very difficult thing. I mean, one of the things as a criminal defense attorney they say is, zip it, right? I mean, the last thing I want anyone doing is giving up their Fifth Amendment right, which is effectively the right to have the state prove the case against you, and because then they're forced to stand on their own evidence or lack of evidence.